or the resolution of Parliament, of the NCOP and the NA, and remitting the framework back to the committees, if the 1st of May would continue anyway. And maybe coupled with that, whilst you're answering that question, the question is, what is the point of the elaborate process of having that is provided for, the process provided for in the PFMA, the Money Bills Act regarding the tabling of the annual budget and the fiscal framework, and it being adopted, if at the end of the day the 1st of May continues anyway?
I think that's a very good question, and that's one of the reasons we say Section 7.4 is unconstitutional, because even after Parliament expresses in the fiscal framework that it rejects a VAT increase, it will come into effect nonetheless. But to answer your question, that's why we challenged both. The effect of setting aside Parliament's decision on the fiscal framework will be to restart the budget process. So it will then not have adopted the fiscal framework. It will have to go back, debate the fiscal framework, and adopt lawfully a new fiscal framework. And after that, the process of the Money Bills Act can follow, the Revision of Revenue Act, the Appropriations Act, and so on. So that's the effect of that part of our case. But I understand this is not the EFF's position, but it's our position that will not stop the VAT increase. That's why we've asked for the other part of the relief, which is to suspend the announcement. And the reason we asked for the suspension of the announcement is because the power given to the minister is an unconstitutional power.
I'm still not clear then, what is the point of the elaborate process that the legislation provides for the tabling of the annual budget that includes the fiscal framework, and in this instance, that includes the proposal for the VAT increase? What's the point of all of that if the parliamentary process has absolutely no effect on the announcement by the minister?
I think the problem, lady, is that there's a disconnect between the budget process in the Money Bills Act and Section 7.4 of the VAT Act. You could rewrite Section 7.4 of the VAT Act to say the announcement is in place until or unless Parliament rejects it in the fiscal framework. But that's not what Section 7.4 says. It requires legislation. So unless and until Parliament passes legislation, that announcement will be in effect. So I agree with you that there's a problem here, that the process, that the first point where Parliament decides on the appropriateness of the VAT increase is when they vote on the fiscal framework. But that doesn't affect the announcement. It's also possible under Section 7.4, the Minister could have said the announcement would come into effect on the 1st of April, before Parliament even had an opportunity to vote on the fiscal framework. So I don't see these as problems with my case, lady. I see these as reasons why Section 7.4 is problematic.
But 7.4 is not untethered to the annual budget.
Yes, that's true.
So that provides some grounding in a way. It can't just come out of nowhere.
That's correct. Yes. Just to round up on these opening remarks, and to address the question you raised, my Lord, the argument that the DA is only here because they've lost in Parliament. Our case is that we didn't lose in Parliament. Our case is that Parliament followed an unlawful process and did not take a lawful decision about the fiscal framework and therefore about the VAT increase. So we said we didn't lose in Parliament. That's why we're here. If I can then turn to the VAT decision. And I just wanted to emphasize quickly what we said, 3 important facts, which are common cause, and that determine the outcome of this case. The VAT increase and the power in Section 7.4 is to raise revenue. It's not to regulate behavior. And that appears from the Minister's answering affidavit, paragraph 45, page 03-23. He says that the increase reflects my best judgment on how to raise the revenue required to fund public goods. No argument is made that this is a regulatory change. And this will become very important when we look at the case law. The second is that it's common cause that it is not possible to repay VAT to consumers. So the VAT that consumers, you and I and everybody in this room, will start paying on the 1st of May when we go to the grocery store, when we pay our bills, can never be returned to us. It is not possible to return that money. It will be forever in the National Revenue Fund. And that's because of the nature of that. Because it's paid by the consumer to the vendor, from the vendor to SARS. And so the SARS will know how much the vendor had paid and can return money to the vendor. But how does the vendor give it back to the Pick and Pay, give it back to the thousands of people who came shopping? So, oh, I owe you R3.22. I owe you R4.76. It's not possible. It won't happen. And that's again accepted by the minister.
Well, what happens if there are emergencies that require some reaction from the Treasury and the minister at the point in time? Isn't Section 7.4 designed for that? That when it is needed and there's a demand for the alteration to take place because the country needs it, under the parliamentary process is taking too long. Wasn't that 7.4 designed for that eventuality?
Yes, so thank you, lady. There's a few answers to that. The first is the point that Justice Savage raised, that it can't be for an emergency because it can only be once a year at the taping of the budget announcement. If there's a shortfall in August, you can't use Section 7.4 to suddenly raise that and increase the revenue. So it's part of a long-term planning process, not part of an emergency revenue-raising process, because it's linked to the budget. That's its purpose. So that's the one part of the answer. The other part is that it's true that in the past, when Parliament has considered a budget, it takes many months to do it. But if Treasury says, and the Minister of Finance says, we urgently need this money, I have a cash flow problem, I am not going to be able to pay salaries in 2 months, I need more money, the only way I can do it is VAT. He can table a money bill to increase the VAT rate by amending Section 7.1 and ask Parliament to deal with it urgently. There's no reason why Parliament can't act within a month or two.
So
or even quicker if they need to.
What's the purpose of 7.4?
It's a good question.
Because 7.1 is there that states what the rate is. But what is the purpose of 7.4?
I think the purpose as the Minister defines it, he talks about financial flexibility and stability. So what he's saying is, from the time I proposed the budget, I need the revenue to raise as I proposed it, because that's how Treasury has planned it. But Treasury doesn't have to operate that way. Our budget doesn't have to operate that way. We've given references to various other countries that don't work this way, where that is not raised by the executive, where that is raised only by Parliament. And those countries operate perfectly efficiently. Ireland, Germany, New Zealand, Australia. They all manage without this power. So I think the power is...
But Mr. Bishop, you must concede there are also countries that work like us.
Yes, that's correct.
And there's nothing wrong with that either.
Well, my Lord, whether there is or not is a question of constitutional law,
Yeah, but
peculiar to each country. We say, for the reasons I'll get to, that under our constitution, there is a problem with it. But yes, I accept there are other countries that have similar provisions. A lot of them are a lot more limited than ours. Ours is exceptionally broad, and I'll get to why. So maybe the second factor I want to stress was that it's impossible to repay. And the third, which is one that I mentioned previously, is that Parliament has, at best, not lawfully endorsed the VAT increase.
So can I just go back to impossible to repay?
Yes.
And maybe connecting that to the issue of harm for now. I'm not going there yet. Isn't the money going to the National Revenue Fund for the purposes, for the benefit of the public? So when you say repay, isn't that at least the money goes to the benefit of the public? It's not necessarily lost.
So yeah, that is an argument the Minister makes. And effectively the argument is that this tax that I've imposed is justified because it is a tax. Because that's what happens to taxes, if they go into the National Revenue Fund. That's the definition of a tax under Shuttleworth and Casino Association McLeod. So he's saying, because it goes into the National Revenue Fund, therefore it's justified. But that means that every executive tax will be justified because it goes into the National Revenue Fund and is used for the common good. But the other answer, my lady, is there's a difference between me having however much I would spend on VAT in the year that the increase would be in place. Let's say I spend it's money out of my pocket. Yes, it will go into the National Revenue Fund and it will be spent on other goods, but I won't have the money. And that's a harm when the decision to take that money from my pocket and put it in the National Revenue Fund is taken by somebody who doesn't have the lawful power to do it.
But how will that change if, for instance, Parliament introduces the VAT?
No, the DA has no problem with Parliament voting for the VAT increase. If Parliament does it, then that's a choice that Parliament has made. The Constitution gives them the power to do it. Our objection is to South Africans being taxed unlawfully. No objection to South Africans being taxed lawfully. So, maybe just to refocus, so I'm dealing with the VAT challenge. I'm going to start briefly with what we're here asking for suspension. It's interim relief for asking for suspension. We say the test is the EFF versus Bourdain test. Is it just and equitable? I'm not going to take the court to it, but the reference in that bundle is page 70, paragraphs 113 to 5. And what Justice Jafta there says expressly is this is a lower test than OTA. It's not the OTA clearest of cases case. When one asks for suspension, it's just what is justice and equity. I'm not going to make too much of this because ultimately the consideration the court will have to consider whether it's under an interim interdict or suspension are largely the same. The court must look at the prospects of success and must weigh the harm of granting versus the harm of refusing. We just think that the test is lower when this court conducts that exercise. But that's as far as the submission goes. So that then goes to the first issue, which is what are the DA's prospects of success in Part B, in its constitutional challenge to Section 7.4. And I want to start by looking at what does Section 7.4 mean, how does it operate. I'm then going to argue that the Constitution, as an absolute rule, does not permit Parliament to delegate taxing power to the executive, and that the case law is crystal clear on that. And I'm then going to deal with why the court, when it weighs the harms on either side, should sustain the minister's decision. So to begin with the Section 7.4, as the court is aware that the rate is set in Section 7.1. There are other tax statutes where the rate is not set in legislation. It's set in schedules or it's set in regulations. That is set in the Act itself. So how does Section 7.4 operate? The first point, which is one that Justice Savage made, is that it can only be done at the budget announcement. So that's the trigger for the minister's power. And the minister makes much of this, and he says, oh, this shows what a public announcement it is. I must do it in Parliament. Everybody will know about it. And that's true. But the other reality about it is that there will be no public process before the announcement. No participation, no draft put out for public comment. The minister announces it, and then it comes into effect on the day he says. It could be the next day. And so this is actually even worse in the sense of what happened in New African Casino Association. In both of those cases, about the regulations before they were enacted, and those regulations changed the tax rates and were then challenged. But at least there was a regulatory process of public participation. Here, everything happens behind closed doors in Treasury. And then there's announced and comes into effect whenever the minister says so. So the second point I want to make is that what Section 7.1 says is that the VAT rate specified in this section is to be altered. So that's a reference back to Section 7.1. So it says in express terms that what is being altered is 7.1. That's what Section 7.4 says. The minister is given the power to alter the VAT rate in Section 7.1.
Does that amount to an amendment of Section 7.1 in the sense that when the minister says this is a temporary power that is exercised and pending the enactment of legislation by Parliament, if legislation is not introduced, then it automatically lapses. That's what the minister says, and then we revert back to what is actually in 7.1.
So I must accept maybe that it's temporary, and I'm going to get to just now exactly when the period would lapse. But so I accept that it is temporary. But the minister, in the next announcement, could make the same alteration that would be in effect for another 12 months and another 12 months. So he'd have to keep doing it every 12 months. But I accept it's temporary. I submit it is an amendment, because it may be a temporary amendment, but it's still an amendment. Because, and I'll explain now why, the only way to undo it is to amend, for Parliament itself to amend Section 7.1. But whether it's an amendment or not is not central to the DA's case. Because we say the problem here is that it's a power to impose a tax. And whether that's done through an amendment to the statute or through schedules or regulations, the Constitution prohibits it either way. It's worse because it's an amendment to the statute itself. But I don't have to win that fight to win the challenge to Section 7.4 about is it technically an amendment or not. So that's my answer there. If we then look at the question you're asking about when will it lapse? So what the text says is, subject to Parliament passing legislation giving effect to that, so it's in effect for 12 months, subject to Parliament passing legislation giving effect to that announcement within that period of 12 months. So it seems to me that there's various possibilities that can happen in those 12 months. So the one possibility is that Parliament passes legislation that gives effect to the Minister's announcement. So it passes legislation giving effect to the 0.5% increase. Then the announcement will lapse because it will be replaced by the amendment to Section 7.1. The other possibility is that Parliament passes legislation with a different increase, a 0.1% increase or 0.25% increase. Then it will also, the announcement will lapse on the date that law comes into force, because it will be replaced by the new change. But there's two other possibilities. If Parliament does nothing, so if it doesn't within the 12 months vote at all on an amendment to the VAT Act, then it's in force for the full 12 months. I think that's very clear from the text of the statute. I think the more difficult question is what happens if Parliament, the Minister puts up a money bill before Parliament proposing the VAT increase, and Parliament does not adopt it. So it either doesn't adopt the Act at all, or it removes the amendment to Section 7.1, and then adopts an Act without any VAT increase, but with other changes to the VAT Act. What does that mean? And I think it's very uncertain whether what the case is then is whether it would continue for 12 months, or if it would lapse on the date that Parliament implicitly rejected the increase. But
isn't the latter more sound?
I think the latter is more principally sound, but it's not consistent with the text, is the problem. Because what it says is that subject to Parliament passing legislation giving effect. So, but I don't think this again is vital to my case, because whether it's in place for 4 months or 8 months or 12 months, it's still unconstitutional. But that's our view on how Section 7.4 operates. But I think what's important about this analysis of Section 7.4 is the only way for Parliament to really stop the announcement is for it to amend Section 7.1 itself, either to adopt the Minister's rate or some new rate, or to, I suppose they could amend Section 7.1 and impose the same rate again. That would stop it. But they have to amend it to get there. So maybe that's how Section 7.4 operates. I now want to get to what's really the core of this part of our case, which is that Parliament cannot delegate its taxing power. And we submit that this is a fundamental and absolute principle if one looks at the cases. And I want to take the court through these cases. Because what they say is that there's certain powers in the Constitution that are expressly assigned to certain bodies. And when the Constitution does that, those powers cannot be delegated. So the Justice Alliance of South Africa case is an example. The power to determine the Chief Justice's term is given only to Parliament. It cannot delegate that power to the President. Taxing is the same. So if the court can go to that bundle, and we'll start with Fetcher, which is really the source of this. So the issue in Fetcher was really about whether a decision by municipalities to impose rates as part of its budget was administrative action or legislative action.
Where will we find Fetcher in this bundle?
The part I will take you to is at page 94, which is paragraph 45 of Fetcher. And this is where the court says, it seems plain that when a legislature, whether national, provincial, or local, exercises the power to raise taxes or rates, or determines appropriations to be made out of public funds, it is exercising a power that under our Constitution is a power peculiar to elected legislative bodies, which is a power that is exercised by democratically elected representatives after due deliberation. So that's really the founding source for this argument. And then there's 4 cases that come after that. And I'm conscious of time, so I'm going to go through them fairly quickly. But the next one is Shuttleworth. So Shuttleworth is about Mr. Shuttleworth, you had a windfall when you sold this company and made, it was 2.5 billion rand and you wanted to take out of the country. And SARS says, well, if you want to take out of the country, you've got to pay 10% in terms of the customs and excise tax. And Mr. Shuttleworth argued that that rate, that 10% rate, had been unlawfully set because it was a tax and it had been delegated from Parliament to the President to the Minister, and that was unlawful. And what the court, this is page 237 of the bundle, paragraph 42, is it endorses what was said in Fetcher. So what Moseneke ECJ says is, a blissful starting point would be to affirm that the power to tax residents is an incident of and subservient to representative democracy. The manner and extent to which national taxes are raised and appropriated must yield to the democratic will as expressed in law. It is the people, through their duly elected representatives, who decide on the taxes that residents must pay. An executive government may not impose a tax burden or appropriate public money without due process and express consent of elected public representatives. That authority, and indeed duty, is solely within the remit of the legislature.
Does 7.4 not do that? Does
Sorry,
7.4 not do that by within the 12-month period having Parliament consider the increase?
For two reasons, no. Because the VAT increase is immediate and irreversible. So it comes into effect before Parliament acts, and it cannot be undone after Parliament acts. It may be different with other taxes like the income tax, because I'm not here arguing about the Income Tax Act. I'm just saying that is the worst example that you can think of. But with the Income Tax Act, if there was a similar provision, and Parliament eventually does not amend the Income Tax Act, people can either withhold the tax because it hasn't become due yet, or they can get a refund from SARS. But it's just not possible with that to repay the money. And so that's what makes that unique here when it comes to these types of provisions that provide for executive action and parliamentary action.
So do I understand you correctly? You are saying that even if Parliament has oversight over the minister, that's after the fact, and the tax rate cannot be undone.
Yes.
Parliament might change it, decrease the percentage, but the amount that was announced by the minister stays for that period of time until Parliament changes it.
Yes, and it can never be undone. The money can never be repaid to the residents. And they were paid a tax imposed without the duly elected representatives having had any say in it.
But Parliament agreed to this legislation.
Well, that can never be a reason why legislation is constitutional. You can never say, well, Parliament adopted it. Our whole point is that Parliament does not have the constitutional power to delegate its taxing power to the minister. So with respect, that the minister makes that argument, but it's not an answer. So how does Shuttleworth comes out, the case comes out against Mr. Shuttleworth? Why? Because the court says there's a difference between regulating behavior and imposing taxes. It says Parliament can delegate the power to regulate behavior, but not the power to tax. And it says what's going on here with imposing charges on taking currency out of the country is a regulatory measure, because what you're trying to do is prevent Mr. Shuttleworth and other billionaires from taking their money out of the country because that's bad for the rand. And so it's a regulatory measure. And therefore it could be delegated. But Shuttleworth affirms the principle in Fetcher. We then get New Africa, which everybody gets very excited about. But New Africa is exactly the same as Shuttleworth. It's exactly the same
Well,
case.
not according to the minority judgment.
Well, with respect, it's two judges, Judge Rogers and Judge Culliton. They sort of have no binding precedent.
I know that, but their reasoning looks to be sound.
But their reasoning was not adopted by the majority. And so with respect, this court is bound by the majority's reasoning, which is very clear. And the majority's reasoning is exactly the same. It applies Shuttleworth. This is at paragraph 105, where it quotes paragraph 48. It says, the question is it a tax or is it a regulation? And it concludes that the issue there, remember that the issue in New Africa was about diplomats buying alcohol and cigarettes and then selling them on. So, and the changes are made to regulate the behavior, to stop the diplomats taking advantage of this loophole and stop them not paying the VAT and customs duties that they should pay. And
But if you look at it narrowly, in terms of the broader scheme of the VAT Act, holistically, isn't the minister just regulating the VAT percentage-wise?
Well, it's not about whether you're regulating the rate, it's about are you regulating behavior? Are you trying to influence the way that people act? So there may be other parts of the VAT Act which would be regulatory in nature. So if you change what are zero-rated goods or you change the exemptions, you're trying to get people to donate more money to charities, to buy certain goods and not others. Not this case, but that may be regulatory.
But doesn't it regulate our behavior, becoming poorer?
Well, it regulates our bank balances. I'm not sure it regulates our behavior. Because we still have to go and buy the goods and services that we need. We're just going to have to pay more for them. And this case is not made by the minister. The minister never says in his answering affidavit, this is a regulatory measure. He says the opposite. He says this is a revenue-raising measure. His whole defense is, we need the money, not we need to stop South Africans doing X, Y, and Z. It's common cause, this is a tax.
Yeah, but the minister also says that in certain circumstances, the plenary powers that he's got is not unlawful because it's limited and Parliament has got oversight over it.
Yes.
So it's not as if he goes on his own and do things that's not within the purview of Parliament. It's not similar to the Smith matter, where
Yes.
the drugs and
Yes.
cannabis was sort of looked at.
Yes. So our answer to that is, it's not relevant if it's a tax. This question, the New Africa test that they said, where they say we're delegating plenary powers and it might be lawful, we've got to consider all these factors. That's relevant if it's not a tax. But the cases from Fairchild through Shuttleworth, through New Africa, through, I'm going to get the Casino Association and Motaba are crystal clear, that once you find it's a tax, it cannot be delegated. You don't get to any other question. Parliamentary oversight irrelevant.
But is New Africa also not, in the true sense of the word, a tax? Schedule has been changed, and therefore those people that wants to buy alcohol duty-free must now pay more for it.
Well, look, that's what Mr. De Beer argued in front of the Constitutional Court, and that's what the Constitutional Court held him wrong. Because he was representing one of those. Yeah. He was representing New Africa. Mr. McKeever was representing SARS. So what the court says in paragraph 110 is which is at page 185 of the bundle, is that he says what one gleans from the long title is that the Customs Act mandates to control the importation and use of certain goods. In this matter, the minister highlighted that the primary reason for the amendment was to curb abuse by diplomats. This in turn informs us that the charge is in fact regulatory in nature. One can disagree with the court's assessment of that, but that's the reason that he gives for upholding it. He says it's regulatory, therefore it didn't need to go through the money-law procedure. And that's the ratio decidendi of the case. So, and that's then applied in Casino Association. So New Africa happens in 2023. In October, the next month, November 2023, we get Casino Association. And what's fascinating about this is it doesn't even cite New Africa. It cites Shuttleworth and Fetcher. And it says, it quotes Fetcher, it says the same thing. This is paragraph 42, bundle page 29. It is settled that the power of taxation...
So you're going too fast for us.
Yes, please. Slow down a bit, Mr.
Fast for
Bishop.
us.
I'm so nervous about time. It's page 29 of the bundle.
Yeah.
Paragraphs 42 to 43. And what Mokhoka AJ says is, it is settled that the power of taxation and appropriation of government funds are reserved for legislature, and that the executive has no power to raise taxes itself. And then it applies the test in Shuttleworth. It changes it slightly because it says you must focus not only on the dominant purpose of the statute, but whether the charge has a nexus to the regulatory scheme. But that's not really relevant here. Ultimately, what it concludes is that this is also a regulatory, not a regulatory measure. It says this one here, this power to change the gambling levy. And I want to emphasize this because the gambling levy was imposed by the Northwest Act. And then the minister is given the power to set the rate. It says that power is the power to raise a tax, and therefore it's unconstitutional. It doesn't engage, after New Africa, in any of these questions about balancing plenary powers and when is it possible. It says it's a tax, end of story. And the court reaches exactly the same conclusion a year later in Motaba. Mhlaba is a case about provincial legislation that affords traditional leaders the power to impose traditional levies on their communities.
So if I understand your argument by referring to all these cases, you're saying that we must look at the dominant purpose of the Act. And if one with regard to 7.4, it's simply clearly to raise tax,
Yes.
not to regulate conduct.
And once you reach that conclusion, it is unconstitutional without more. Yes, that's what the case has said.
Is that you mean your case is so simple?
Yes, very simple.
Mr. Bishop, is the tax not raised in 7.1? And then for purposes of Mhlaba and Casino Association, that's where the raising takes place. And therefore the amendment to the rate that occurs in 7.4 is something different.
Yes. So this is an argument that's raised by the Minister. So I've already said I think that's inconsistent with Casino Association, because the same structure was in Casino Association. It was set in one section, and the power it was imposed in one section, and the power to amend was given in another section. It's also inconsistent with FEDSHA, because in FEDSHA, this is page 95 of the bundle, paragraph 46. The court, just after it says what I read out to you about the democratically elected legislators can impose taxes, it says that the argument of the challengers there was that the resolution had none of the ordinary characteristics of legislation, and that the levy was not of general application, applied for a limited period of time, and did not have to be promulgated. We have already decided that the resolutions to adopt the budget were not administrative actions, and then this is the important part. The resolution of the TMC, taken for the purpose of raising the levy and paying the subsidies, formed an integral part of the adoption of the budget, and as such constituted the exercise of taxing and spending powers. Such powers are constitutionally vested in the legislature in the exercise of appointing not administrative actions. So even though it's temporary, and Casino Association says even though it's imposed in another section when you change it, and one can just think about it logically, that the minister could, under 7.4, decrease that to 0%. He could raise it to 100%. And I think it would be strange to say that when he did that, he was not imposing a tax or undoing a tax.
So you're saying we don't need 7.4 at all?
No, it should be. That's when we have case in part B. It should be struck from the statute completely, yes. That's the case.
So what happens if there is, what contingencies are there in place when there is a need for the minister to intervene at a point in time?
He must ask Parliament to pass legislation urgently to amend Section 7.1 of the VAT Act.
I mean, going back to my initial question, isn't this a recognition that those processes take too long? And so Parliament recognized that by introducing 7.4 to say that for an interim period, with these conditions, we are going to give you this power. But this power is not absolute, because at the end of it all, we have the power to change, to alter what you've actually put, but you're just putting this for this period.
My first answer, lady, is that whether it's convenient or useful or expedient is irrelevant, because Parliament doesn't have the power to do it. It may be good policy, but the law that the Constitutional Court has said is that Parliament cannot delegate the power to tax. I still want to get to Mhlaba.
Yes.
But that's the first part of my answer. The second part said there's many other countries that don't need this. This isn't universal. The third is this is not an emergency power because it's linked to the budget. So it's part of the planning process. And the third is it may be true that Parliament thinks this takes too long, but that's can never be a justification for delegating their taxing power, saying we're too slow, therefore we're going to ask the minister to do it. The solution is for Parliament to act more swiftly. And the Constitutional Court has said, for example, in Doctors for Life, that when Parliament needs to act urgently, it can and it must.
But if one have regard to the constitutional scheme currently, it's only the Minister of Finance that can introduce a money bill.
Yes.
No other member of Parliament may do it.
Yes, that's another problem with Section 7.4, because the minister controls what gets in front of Parliament and controls when it gets in front of Parliament. So
even if the parliamentarians shout and scream about the VAT rate, they can't introduce a bill or money bill to saying we can have one to lower it. They have to wait for the Minister of Finance.
yes, and if the current Minister of Finance won't do it, they can always get a new one. by electing a new government. But yes, those are the only powers that Parliament has. No, I didn't mean that facetiously. I mean that's Parliament's
Is
power.
your client so eager to be
Exactly.
to take over Parliament?
But that's the lever that Parliament has, because you're right, Parliament itself cannot introduce the bill. It must wait for the Minister of Finance, or it's so upset with the Minister of Finance for not introducing a bill. Its only remedy is to a motion of no confidence in the Cabinet. That's the constitutional scheme. I'm not talking about politics. I'm not a politician. I'm a constitutional lawyer.
I'm just saying. But as my learned colleague, presiding judge, indicated, isn't that the reason why Parliament has introduced 7.4?
I'm not sure that that's a reason for 7.4, because without 7.4, the minister can still introduce a money bill to amend the VAT Act at any point in the year if there's an urgent need to raise cash flow and ask Parliament to deal with it urgently. It cannot be, I would submit, that Parliament says we sometimes take a while to deal with legislation, therefore we're going to delegate this core power it's called democratic power to the executive, when there's no legal reason why it cannot act swiftly, and there's no practical reason why it cannot act swiftly. All we have is that it hasn't done so in the past. And then if I may briefly, let's go to Matlaba, because I submit it is important, because it's the most recent case. It's from November last year. So it's at page 158 of that bundle, paragraph 17, where Justice Turon says, this court has repeatedly held that there must be a direct constitutional source for the power to impose a tax. The Constitution only affords a taxing power to the three elected spheres, and the power to tax cannot be delegated to the executive.
And I noted that C refers to Shuttleworth.
Yes, because that's what Shuttleworth says. But Shuttleworth responds it's not a tax. And then in paragraph 20 on the next page, the Constitution reserves the taxing power of the legislative bodies.
Sorry, paragraph?
Paragraph 20.
That's on the same page.
Oh,
Same page.
my notes are incorrect. The Constitution reserves the taxing power of the legislative bodies, and that when it permits the imposition of tax, it does so expressly and regulates how the power must be exercised. Legislative bodies can delegate the power to regulate, but not the power to tax. Full stop, end of story. No balancing act to be performed. And that's the way the case comes out. It considers, is this a regulatory charge or is it a tax? It finds it's a tax, and it says therefore it's unconstitutional. Because the provincial legislature is supposed to delegate it to traditional leaders and the transition. So we submit that we have very, very strong prospects of success in Part B.
Okay, so we don't need to finally decide this point, this issue, because...
Sorry.
Yes, go ahead.
No, we're not asking you to declare Section 7.4 unconstitutional, but we submit it is important that there is no answer to this. That when we get to Part B, the prospects that we will win Part B are extremely high. And that weighs when this court is performing the just and equitable analysis of whether to suspend the minister's announcement. That's obviously an important factor. And that's why I spent quite a lot of time on it. Maybe I want to deal with some of the minister's defences. Most of them have been raised by the bench. But if I may just quickly make sure I've covered all of them. The one argument the minister raises is that even if we are successful in Part B, the Constitutional Court may ultimately suspend the order of invalidity. And so if it suspends the order of invalidity, it would mean that the minister's announcement would still be valid. So the argument is the relief we seek in Part B doesn't necessarily entitle us to the relief we seek now in Part A. So we submit that there's a few problems with that. The first is you've got to distinguish between retrospective effect and suspension. We accept, and you'll see the relief that we seek in paragraph 3 of our notice of motion in Part B, says that the order must have effect from the 1st of March 2025, because we don't want to undo the 2018 VAT increase. So there was a VAT increase in 2018, we don't want to undo that. We want to stop this one coming into effect. And then it must operate from the 1st of March. In terms of suspension, we don't think there would be any basis for the court to suspend the order of invalidity, because for all the reasons I've already given, it's not necessary for the minister to have that power. And so there would be no basis for suspension of the order of implementation.
Mr. Bishop, in terms of the announcement, the minister also announced that next year there's another 0.5% from March 2026. What about that?
So I think that's dealt with in the relief we seek in Part B, which we hope will be determined at least by this court before then. Yes. So paragraph 3 of our Part A relief applies to both. Sorry. So this is what we're asking this court. Paragraph 3 is the operation of the first respondents announcement on 12 March to increase the rate of VAT by 0.5% with effect from 1 May and by a further 0.5% with effect from 1 April. So we're asking for the suspension of both because it was a single announcement. And it's been dealt with by Parliament also as a single issue. So lady, just to conclude on this question of the prospects of success, we say it's common cause, it's a tax, it's immediate, it's irreversible, it's unconstitutional, full stop, end of story. We made a separate argument in our papers, which we'll pursue in Part B, that it's a plenary power because it's to amend the statute effectively. But we don't have to convince this court or the Part B court about that argument. I think that there's a tension between the decision in New Africa and the decision in Smith, and it's difficult to know how you square those two decisions. But it ultimately doesn't matter, because even if Parliament had delegated the power to the minister to change the VAT rate by amending a schedule or by amending a regulation, it would still be an impermissible delegation of the power to tax. We submit it's made even worse because the rate is set in the Act itself. But that's not necessary for us to win the challenge. So I then want to get to the question of the exercise of this court's just and equitable power and why it should exercise that to suspend. So we said you've got to weigh the harm of not suspending versus the harm of suspending. And you've got to do that cognizant of what the position is in Parliament. And we submit that there's 3 important factors. And I'm going to get to the facts on this when I get to the fiscal framework challenge, but I submit that I will show to this court that Parliament rejected an unconditional VAT hike. That the only VAT hike Parliament approved when it considered the fiscal framework was a conditional one, in the sense that it was conditional on the consideration of further alternatives and a vote in Parliament on whether to adopt those alternatives. So Parliament has not endorsed this VAT hike. The decision that Parliament did take was an unlawful decision. And if one looks at the public statements of political parties and one counts the numbers, in both the National Assembly and the NCOP, at least at present, if the vote was taken today, the VAT hike would not pass. So I'm not saying that means when it gets in 3 months, politics, 3 months is a long time in politics, it may be very different then. But there's at least a very good possibility that Parliament will ultimately reject this VAT hike. And that's important consideration when this court decides whether to suspend or not. Because if Parliament had unanimously endorsed that every political party said, we agree, we must have a 0.5% VAT increase, and I was here asking this court to suspend it, I would have a difficult case. Because even though there might be a technical unconstitutionality, in substance, there would have been endorsement by the democratically elected representatives. But that's not the case here. Those are not the facts for this court. The facts for this court are that, at best, it's uncertain whether Parliament will endorse it, and in fact, Parliament has not endorsed it when given the opportunity to do so.
What is it that was adopted? Because the fiscal framework had that increase as part of the report. And so when the report is adopted, what is it that's being adopted?
Yeah, I don't want to avoid the question, but may I answer it when I get to the challenge on the fiscal framework?
Okay, I thought you were getting there. Okay.
But I will answer the question directly.
That's fine.
So that's the first point. The second point is, what is the harm of allowing the VAT increase to come into effect? And we submit that there are 2 important harms. The first is that it's an irreversible...
Doesn't it speak for itself? I mean, if you increase the VAT rate, you can't claim it back.
Yes. So and I've dealt with this. The first point is irreversible, it cannot be undone. So this is unlike OTA. So OTA is an interesting example. Remember, that was about e-tolls. And one of the things that Justice Montenegro said there is that there's no irreparable harm because you'll be able to bring an unjust enrichment claim to recover your e-tolls that were unlawfully paid. And that would be possible there because you would know how much e-tolls you paid because the camera would flash at you every time you drove under the boom and you'd get a bill for you had all these e-tolls. And if ultimately it's declared unlawful, you can go and reclaim that money. But that's just not possible with that. Practically it's impossible. And everybody accepts it's impossible. So that's the one important thing. The second important point is that the effects of the VAT increase will be negative and will be felt most severely by those who have the least. And this is not the DA's view. This is the view that adopted by the committee. So if the court goes to page 02-183 of the record.
Just repeat that.
And my learned Mr. De Beer should be directing you.
Yes, I've got that. Thank you, Mr. De Beer. Yeah, 02183.
Yes, paragraph 4.3.1.
What is that? What?
That's
the case
final report of the National the Committee report served before the National Assembly.
It's 02183.
So what the committee... So it's an annexure to the founding affidavit. It's annexure DA 13. In my papers, it's having it page 196, but I'm trying to be technologically advanced in these things. Do you have it there? So what the court says is the committee is talking about the concerns. So the concerns raised include that the VAT increase would disproportionately impact middle and low income households, not just the poor, would cut into households' discretionary spending, diminishing their quality of life, and potentially exacerbating poverty and inequality. So this is recording the submissions that were made. Further down at the last paragraph, the stakeholders were further concerned that VAT is a regressive tax that disproportionately affects the working class and struggling businesses. And then the committee adopts those. So at page 02-199.
But you didn't finish the sentence there.
Sorry.
It says here, it is not backed by concrete evidence that it is less harmful to growth than other taxes, and it has not been researched enough to determine its potential impact and implication. And its alternatives have not been thoroughly interrogated.
I agree with all of that.
Okay.
I'm just worried about time. I agree with all of that. So then at 02-199, at paragraph 6.28.3, so the committee notes that increasing VAT will have a disproportionate adverse effect on lower and middle income households, exacerbate inequality and the cost of living due to its regressive nature. So the burden is although people with high incomes pay more VAT, they can afford it. People with lower incomes pay in total less VAT, but it's a bigger proportion of the income that they pay, so they feel it more. And so that's endorsed by, I don't want to take the court all of it for time reasons, but if I can just briefly give the references. By the Budget Office, where it says an increased VAT will disproportionately burden middle and low income earners. That's at page 06-79.
But are you not taking us to the question of whether or not VAT is bad or good, is good or bad?
No, maybe. I'm taking, that's a decision for Parliament to make.
Yes.
But this court has to decide whether to suspend the announcement or not.
What I mean, if you talk about the impact that it has on low-income households, and the impact that it has vis-a-vis the high-income households, isn't that going to whether or not VAT is bad or good?
No, well, that's ultimately a question Parliament will have to decide on its merits.
Yes.
What I'm saying to this court is you're confronted with not a decision by Parliament, but an announcement by the Minister.
Yes.
That announcement was made in terms of an unconstitutional law and has not been endorsed by Parliament. In those circumstances, one must consider the need for the VAT hike, which I'll get to, and also the consequences of it. This court must consider that in order to decide whether to suspend it or not. This court may suspend the VAT hike and stop it coming into effect. And Parliament may still say, we still think it's a good idea, and we're going to exercise our democratic role and bring it into
And the court can't interfere with that.
It mustn't. It mustn't. It's not for the minister, and it's not for this court to decide that ultimate question.
Yeah, because then the court will interfere into the reign of Parliament, which it can't.
Just as the minister has. Yes. And so this court should stay out of it, but it can't stay out of deciding what happens in the interim. And it can't close its eyes to what the consequences of imposing the hike would be. But leaving open the ultimate question of how Parliament, when it actually exercises its power, weighs these competing factors. This court must not decide.
Okay, you have 15 minutes. Just as a reminder, I'm not rushing you.
Yeah, we also refer to, but the point is made. So those are the problem, the harm that will be done if the announcement is not suspended. What are the harms the minister says will happen if it is suspended? So the first is he says we'll lose 13 billion, sometimes it's 13, sometimes it's 13.5 billion rand. But we submit that firstly it's a wrong number. 13 billion is what can be collected over the full 12 months of a 0.5% VAT hike, with the estimated revenue. But what we're asking the court to do is not to say you cannot have a 0.5% increase for 12 months. We're asking the court to say you cannot have a 0.5% increase until Parliament decides. So when Parliament decides, it votes on the bill that is before it, which amends Section 7.1 to increase the VAT rate. If it adopts it, it will come into effect. And if it rejects it, the minister can hardly argue that that's harm from that point onward, because then Parliament would have said we don't want the income, and we've either found other income or we've reduced expenditure to address it. So the question is for how many months until Parliament takes a decision? We say it's likely to be in June or July, so it's 2 to 3 months from 1st of May. And how much is lost then? So it's 13 billion over 12 months, it's about 1.1 billion a month. So we're talking about 3.3 billion. What percentage of revenue is that? 0.099%. Less than 0.1% of total revenue.
Mr. Bishop, can I ask you this question? Do I understand it correctly that the minister did introduce the money bill?
Yes. Yes. I forget the name, it's got a long name. It's the Revenue and Something Matters Amendment Act. But yes, there's a bill before Parliament that to amend Section 7.1. It's attached to the founding papers. Yes.
So even if, and that's still a big if, we're with you, Parliament can, for argument's sake, tomorrow change it and introduce the VAT
Yes.
rate.
Well,
And that's
it probably couldn't do it tomorrow, but it could
No,
do it
I'm just
within
saying
2
that.
weeks. It could fast track that process because, well, I should give an honest answer to this. It depends what happens in the second part of the case. Because if this court sets aside the fiscal framework, Parliament would first have to adopt a new fiscal framework before it can consider any of these bills. Because under the Money Bills Act, you first need the fiscal framework before you can get into DORA and Appropriations Act and Revenues Act. But once the fiscal framework is lawfully adopted, Parliament, these revenue bills can immediately be considered. There's no ordering in the Money Bills Act. It says you must do DORA first, and then you must do appropriations. But it doesn't say when you must deal with other revenue bills. So those could be dealt with immediately. The other point, so the first one is it's a very, very small loss of income we're talking about, less than 0.1% of revenue.
But that revenue goes to the very poor. I mean, the minister says it's going to certain grants. He wants to appoint more medical doctors in the hospitals. It will affect the poor, the poorest of the poor.
So there would be 0.1% more doctors for these 2 months. And the price paid for that is having less money in your pocket. That's the reality.
But isn't that the scheme that we've accepted in terms of the democracy that we're staying in? I mean, this is how we need the money in order to do all of these things.
The important word in that question, Lord, is democracy. And democracy means a decision taken by elected representatives, not by National Treasury and the minister without public participation. Democracy means it's taken by Parliament. And so if Parliament adopts it, Parliament adopts it. But if it's not adopted democratically, that trade-off hasn't been made by democratically elected representatives, then it should not be imposed on people. And the other point is about the extent of loss.
I'm just worried about the time. I'm anxious for you to get to the second issue.
I'm almost finished with the first issue.
Yes.
And I think the second issue will be much quicker. I might need another 10 minutes
Okay.
to finish that, but it's going to be much shorter than the first issue. On the Financial and Fiscal Commission also told Parliament that the amount of income they would likely get is less than you expect. If I can just give you the references, it's 02-184 and 02-199. So what the committee accepted is the probability that the proposed VAT increase might not meet the expected revenue in a constrained economic environment and weak outlook. So 13 billion is just an estimate of how much you're going to get, and the committee accepted it's actually likely to be less than that. But the second harm is the minister says, if you don't give me the 13 billion rand, which we know is really 2 to 3 billion rand, then the government will either cut planned spending or increase borrowing. The answer to that is really that there are alternatives to raise the revenue. And these are also dealt with in detail in the committee's report. Again, I don't want to take you there, but I can give you the reference. It's 02-233, where in particular, the committee notes SARS's estimated tax gap of about 800 billion, and that even with the 30% recovery rate, this could yield over 200 billion in additional revenue. And there's a range of other alternatives. The fiscal framework, and I'll get to this now maybe, is adopted on the basis that National Treasury must come back and propose alternatives to raise the 13 billion or to cut spending. So it's not that or nothing. There are other options. So maybe for all these reasons, we submit that this court, when it exercises its just and equitable power, should suspend, because the cost of doing so is an immediate, irreversible tax increase that will affect the poorest and the middle-income people the most. And the cost of doing it is minimal, less than 0.1% of revenue when there are alternatives to fill the gap. So maybe that brings me to the second part of the case, which is the attack on the fiscal framework. And we submit that there are three issues the court, three primary issues. The first is...
But, I mean, reading what transpired there, it looked like chaos, to say the least.
That's very generous. I'll get to what actually happened, but chaos is a generous description.
No,
I think, not only chaos,
I think you need to take us to what the irregularities were.
Yes.
Because
yes.
the process is quite important for us to understand what is irregular.
Yes, and I will get to it exactly. But if I just say what we say the issues are is, were the final reports before the National Assembly and the National Council of Provinces consistent with Section 8.4 of the framework of the Money Bills Act? 2, was the process the committees followed lawful and consistent with Section 8.4? And finally, there's a question Parliament raises, which is, should we have challenged the decisions of the committees and not just the decisions of the houses? And just to telescope my argument, even if you accept Parliament's version that the committee's reports just had a non-binding recommendation, it's still inconsistent with Section 8.4. But if you look at what actually happened, it was not a non-binding recommendation. 1, it was a strict condition, and 2, no vote was ever taken on the fiscal framework. And when one looks at what happens in the committees, that's clear, and it's actually common cause. So I want to start very briefly with the purpose of the fiscal framework. And I'm just going to have a long argument on this, but I'm going to summarize. The purpose is to set the revenue and expenditure estimates for the budget process. And those then bind Parliament in proposing amendments to the various money bills that follow. The Division of Revenue Act, the Appropriations Act, and the Revenue Bills. Parliament cannot propose amendments to those acts that are inconsistent with the fiscal framework. So once it accepts that we're going to have 2.2 trillion rand of revenue and 2.4 trillion rand of expenditure in the fiscal framework, those are the numbers that have to come out in DORA. So when the Division of Revenue Act, Parliament divides money between the provinces, national and local government, it must divide the 2.4 trillion that it agreed to when it adopted the fiscal framework. And when it considers the revenue bills, it must raise the 2.2 trillion that it agreed to when it adopted the fiscal framework. It cannot spend more and it cannot raise less.
So what happened if Parliament amended the fiscal framework to put the alternatives and removed the VAT increase? What would have happened there?
Then, because it's not the minister that sets the fiscal framework, it's Parliament.
Yes.
So the minister would have proposed one. Parliament could have amended it. Could have amended it in different ways. He could have said, we're going to take out the 13 billion and we're going to cut 13 billion from expenditure. And then it would have a fiscal framework that complied with the requirements, and that would have then bound them going forward. They have 13 billion rand less to spend. Or it could have said, we're going to raise the 13 billion not by raising the VAT rate, but by borrowing 13 billion, or by taking it from the reserves, or by raising income tax or some other money, the various alternatives that are in the committee's report. But what it would have to do is balance revenue, borrowing, and expenditure. And whatever it decided when it adopted the fiscal framework would govern what it does when it adopts legislation going forward. But that's why the fiscal framework is so important and why it must be clear and it must be final. You can't have a fiscal framework that is subject to amendments down the road, because then you don't know what your limits are when you pass the Division of Revenue Act, the Appropriations Act, and the other acts, because they're still up in the air. And that's why Section 8.4 says that the report must include a clear statement accepting or amending the fiscal framework.
Can you just take us through the process of what actually happened?
Yes, let me, Melanie, if I may, I don't want to keep avoiding your question, but I want to deal with it in this way.
Because I think that's quite important, because we have to know what was wrong with the process.
Can I answer first on Parliament's version? Parliament says it doesn't really matter what happened in committee. Look at the report that ultimately served, the final reports that served before the National Assembly and the National Council of Provinces. And it says all those did is they had a non-binding recommendation, and those were adopted by the houses, and that's good enough. So one has to look at what is that non-binding recommendation. And it appears at page 02199 for the National Assembly. You don't have to go to this other one, but the reference for the NCOP is 02235. It's identical. And in paragraph 6.29,
6.29
and 6.30.
Yes.
The committee recommends that the Minister of Finance facilitate the receipt of substitute revenue proposals from the committee, together with corresponding expenditure savings, that will form the basis of an alternative revenue proposal instead of the proposed 0.5 percentage point increase in VAT, in respect of which the committee has expressed serious concerns. Furthermore, the committee recommends that the alternative revenue proposals and expenditure savings to balance the 28 billion rand shortfall, which must effectively suspend the proposed increases, be finalized and submitted by the committee to process within 30 days, and this is very important, for consideration and adoption of this report by the House. So what it's saying is we are having a recommendation that National Treasury must consider our proposals, come back with its own alternative revenue proposals within 30 days for consideration and adoption of this report by the House.
But then what was approved? What was approved?
So you've got to read the report as a whole. The report does contain the statement, having considered the 2025 fiscal framework, blah, 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 the committee accepts the 2025
Where are you reading from now?
So this is at page 02204. So it's right at the end of the report.
Okay.
So this comes first, the recommendation, and then right at the end of the report, this is tacked on.
But that's belatedly tacked on. I mean,
Yes.
the minutes suggest that something was approved in the committee.
Yes, maybe I'm going to get that, but I'm saying even if one ignores what happened in committee, even if what happened in committee was squeaky clean, what served before Parliament, before the Houses and plenary, was inconsistent with Section 8. Because although it contains a statement of acceptance, it's subject to a recommendation. It's subject to a recommendation that envisages a change to the fiscal framework. Because if National Treasury comes back with alternative revenue proposals, and those are considered and adopted by the House, that means that there won't be a VAT increase, and the fiscal framework will be different.
But reading between the lines, isn't that what ultimately the committees wanted to achieve?
Yes, but they weren't allowed to do it by the Money Bills Act. Because the Money Bills Act doesn't allow you to set the fiscal framework and say, but we might still change it later. You've got to set it and stick by it. Because it's so important in regulating what happens thereafter in the budget process.
But it requires acceptance or amendment.
Yes.
So why did the committee then not stand firm on giving neither?
Yes. So if I can let me get to what actually happened in the committee, because I think that's important. So we say that there are 5 important acts. So the first is that the draft reports did not include a statement accepting the fiscal framework. That's common cause. Parliament says the reason is that the committees first had to decide whether to accept it, which is fine if Parliament either amended the report before the vote in committee or took a vote on the fiscal framework in committee. But it is also common cause that the committee did not vote on the fiscal framework.
But what did they do then?
So what they did is that
Is there a transcript of the meeting?
there isn't what we provided as a YouTube video.
We couldn't find it. Can you maybe send us a link? Someone send us a link,
Yes.
because
the other parties have managed
we
to do
couldn't
that.
find it. We tried to locate the YouTube link that you sent us, but we couldn't.
Could you resend it?
Yes, but what I can also try to do is provide a transcript to the court.
Okay.
It would probably take a
How
day or
long
two.
are you still going to be? Can we give you 5 more minutes? But when we come back from tea, we're going to adjourn and then come back. Unless you want to close this point quickly.
No, maybe at the tea now. I'll need 5 to 10 minutes.
10 minutes is a long time. You have to ask your colleagues to to borrow some of their time.
In my
Okay.
defense, I'm the only person who has to address both.
Okay,
parts of the
that's
case.
fine.
So it has taken a little bit more time.
That's fine. We'll give you 10 more minutes when we come back, and we'll have to readjust the time perhaps at lunchtime. All right, the court adjourns.